Good morning, my name is Larry Ewing, and I'm with the firm of CDH. I have been in the state and local tax area for more years than I care to remember anymore. It's far in excess of 20, actually in excess of 25 at this point in time. So it's something I've worked in. I think the amazing thing about state and local tax is that the amazing is a term you would apply, is the fact that it's more based in kind of a grassroots kind of thing. States tend to pass laws that influence their own economy, the business within them, things of that sort. Now, when I was first approached by our marketing director, the topic she had selected was Illinois and local tax changes. This was a few months ago, and I thought, well, by then there'll be some changes, right? Unfortunately, there hasn't been any changes. So what I've tried to do is at least changes that directly affect manufacturing companies. So what I've tried to do is select things that have happened that might be of interest or tangentially might affect manufacturers. So with that said, let me start out here. Thought I was going to start out here. There we go. First case I'm going to talk about is actually only a circuit court case. So it's a low-level court case. Not really super important at this time, except what it stands for. It's sort of the first one of this type of case to really happen in Illinois. Capital One Corporation, obviously a financial company, a banking company. And what was really at question here is Illinois could tax them or not. In other words, if they had nexus or taxable contact with the state. And what was really pointed out by both parties that there wasn't really a good definition of substantial nexus in Illinois law. So what they decided, they'd use a test called significant economic presence, and they had to look all the way to West Virginia for a case that discussed this. And eventually the court decided that, well, the company did have substantial economic nexus. Why? Because they collected millions of dollars in fees and interest from Illinois residents. They systematically and continuously engaged Illinois customers via the telephone, email, all the modern forms of communication. They used the Illinois courts to recover debts and delinquent accounts, and also filed and enforced judgments, liens in Illinois. So in other words, I assume they probably used various sheriff's offices, what have you, to actually go out and collect some of this stuff. Now, part of the question here, this is obviously kind of a company that deals in intangibles. You know, they don't deal in tangible property or anything like that. So, you know, at issue, and it's a bigger issue that goes more to the second probably presentation today, from a multi-state idea. A lot of the old ideas of economic, you know, what was nexus, which had to do with presence, if you would, doesn't always really measure, I guess. This is the contention of the states, doesn't truly measure presence of a company within its borders. I point this out because Illinois hasn't gone real far in this economic direction yet. So, you know, things like this, unless this gets struck down by a higher court, you know, courts grab onto this. The state tends to grab onto these economic nexus type ideas and expand on them. So this is something worth keeping an eye on. Again, if you're a manufacturer and you're in Illinois, you probably have tangible presence here, so you won't get into this, except if a real big manufacturer might have its own financing company or something like that, this could come into question. Next thing is Governor Rauner recently came out with I think it might have been an executive order, but at least a statement that it's going to start releasing edge credits and the film production credits now, but really only as soon as there's a budget in place. So don't expect this to happen tomorrow, I guess is what I'm saying. But there are several changes that are going to be placed on the edge credits. There will no longer be special deals cut for companies, you know, particular companies by DCEO. You're probably aware the last few years there's been special edge credits cut for various companies such as Ford and other manufacturers too. You might have seen the commercials touting them with Governor Quinn and even President Obama in them. The edge credits are no longer available for job retention. Does anybody here work for a company that's got an edge credit, or at least they're aware of? It used to be that the initial concept was you would just get credit for projects you're doing that would increase employment. And then they got more and more. I would bet if you tallied them all up, most are really given for retaining employees within the state. Now along this the same vein, new job creation won't just be measured against the project now, be measured against existing jobs in the whole state. And you'll see too, multiple edge credits are no longer available for the same facility. And the reason for this is a lot of employers would get these edge credits, but they would play shell games with them. They'd open up a new factory in one town in Illinois, but then close another factory in another town. So net, Illinois didn't really pick up anything, but they still ended up with the edge credit. So they're trying to close that opportunity for people. Again, they still won't be certified until there is a budget, although as of January 1st, there's going to be a DCO will commence certification of 49 new enterprise zones. So a little activity there, but nothing big's going to really happen until Illinois has a budget in place. There we go. The next thing I'm going to talk about, how many are familiar with the Hartney case? Anybody? You don't count. Anyhow, though, this actually came out in 2013, and the regulations for it really came out in 2014. But the reason I'm mentioning it now is twofold. At the end, I'll mention a couple of cases that are still going on. They kind of involve the same issues here. And the second thing is, a lot of my professional colleagues and I believe that a lot of people aren't checking out these regulations. And it's very important. What these regulations address is the sales tax, specific sales, local sales tax that's charged in Illinois. Illinois, of course, the tax runs from, depending where you are, from about 6.25%, which is the basic state, what some people call the use tax rate, to up to about 10.75%. Depending if you're in the media district and buying food and things of that sort. So it really varies, so it can be a big number, and something that on audit you don't want to be on the hook for maybe 2 or 3% of your sales because you charged the wrong rate. Now a lot of manufacturers, of course, everything they sell is for resale. However, if you're a manufacturer, let's say, sells to contractors, people take what the manufacturer makes and put it into a building. That very well can be a taxable sale. Contractors are looked upon as the end user of things that's incorporated in realty. So unless they're working on an exempt government type project or something, they're going to have to pay tax on that, and the manufacturer will have to charge a tax. Also too, a lot of manufacturers deal with what I call consumable type products, like food products, candies, different things like that, that they might sell over an internet website or through company stores, things of that sort. So in particular, these are the people that have to be interested in it. The other thing is, if you have a very large vendor you're dealing with, you might want to be interested in if they're collecting the right amount of tax or not. This can be important because I also chair the Sales and Use Tax Committee for the Chicago Tax Law. I have about 13 other people in the committee. They're like me, consultants, accountants, attorneys. And there's been some question come up down the road when these things start being audited. If the seller is no longer around, out of business or whatever, and didn't charge the right rate, is the Illinois Department of Revenue going to be able to go after the customers for the tax? We think it's a fishing expedition, probably not. But if they've kind of identified the facts, there's some thought that there's a chance that might happen. But again, that's speculation at this point. So let's get a little further into the Hartney regulations. Oh, this thing is really chunky. The regulations go on the premise that selling is the composite of many activities extending from the preparation for, the obtaining of, orders for goods to the final consumption of the sale by passing title and payment of the purchase price. Another principle is kind of what they call proxy. The idea of this is that the jurisdiction that should get the local tax should be the one that's really putting out the most money to give benefits to the taxpayer, who's providing the fire department, who's providing police protection, these sort of things. That the local government that's doing most of that should get the sales tax revenue. Here they're basically saying, because of practicality and everything, that only one location in Illinois is going to get the local tax for a particular sale. The idea is that this cannot be, unlike income tax, the sales tax can't be apportioned between different jurisdictions. The only case I've seen kind of address this recently in Illinois, this is from a couple of years ago, I think was ITW or something like that. It involved an airplane that was in various states. And the thought was, well, maybe Illinois shouldn't get all the sales tax on the plane, but maybe some of it. And then finally it was decided they wouldn't apportion it. Now, as always, Illinois put a provision in these regulations that they might look through the form of the transaction and come up, if the rules I'm about to discuss in their mind don't give, a fair result. Illinois can kind of go in and play with that and change it. So that's probably very disconcerting because not everybody knows, obviously at this point in time, how far Illinois might take that. The example they gave where they may want to change it is the department will not look to the location of a party that is owned by or has common ownership with a supplier or a purchaser if that party does not in substance conduct selling activities related to the sales, and then they mean in a particular jurisdiction. So what they're saying, no fun and games on this reorganizing or setting up subsidiaries or something like that to get a favorable tax result. Let's get into what created all this and why we're talking so much about the local rates. Well, as I said before, the basic state rate is 6.25%. It varies greatly. And before, what was the idea of who got it? Well, the previous regulations stated that the single most important aspect of a sale was the acceptance of the order. And where that acceptance occurred, that is where the tax rate in that jurisdiction is what should be charged, and that jurisdiction accordingly would get that local tax. Now, what happened is originally companies would try to locate their order acceptance. They try to strip that out of the company, maybe make it a separate office. And some companies started putting that in its jurisdiction. Originally, the way it started out, they put in a jurisdiction they had no local tax rate. I don't know if it's still true, but Dixon, you may recall that town was in the news a year or so ago. A lady that ran the town had absconded over the years with like $45 million or something like that. Had a nice farm, a lot of horses, things of that sort. Dixon, last time I looked, only charged 6.25%. They had no local tax rates or anything like that. So that's the type of place companies would originally maybe place the order acceptance area. Then a strategy grew, and it's never really clear to me who started this, either municipalities like Kankakee or Shanahan, or perhaps it was the companies, but here was the deal. If I'm a town like Kankakee, anybody here from Kankakee? Okay, so it's fair to pick on Kankakee then. So what they would do is say, if you locate your order acceptance area here, where you accept orders, we'll kick back to you half, or that percentage would change, but some percentage, usually half, of the incremental sales tax the municipality received from you being there. Now, I don't think that was quite the intent of the Illinois Sales Tax Act, or RT Act, everything, but that was the deal they cut. And turned into a lot of money a lot of times. And these ideas grew to the point where a lot of times the order acceptance area would be nothing more than kind of a corporate identity. You'd have one lady, you know, accepting orders for like 50 companies. And actually what happened in some cases, the company's computers or whatever would see the order and shove them over that person, but that's supposedly technically where they were accepted. And what grew out of this was a lot of litigation. One of the more famous ones, I think, was Siegel's. They had an agreement of this sort with the town of Elgin. And then I think it was Hampshire, but I'm not sure, offered Siegel's a better deal. So they wanted to change where their order acceptance point was. You know, Elgin said, hey, no fair, we had a deal and everything like that. So you start getting litigation between the towns. In addition, the Illinois Department of Revenue became very frustrated because these local rates they collect on the ST1 and ST2s and everything, the state doesn't get that money, that's local. But they have to administer it. And nothing is worse than trying to administer this when you have municipalities wrangling about who should get that local tax. State got kind of tired of being in the middle on a lot of this stuff. So they started auditing and going after them. And that's basically how the Hartney case, Hartney was an oil company, how they ended up in court. So an issue here is Illinois, and I don't know why the Department of Revenue never came up with regs that really detail this, but they were saying, you know, acceptance is more than getting a paper order handed to you by the mailman. There's some other stuff that has to occur. And that's the way they would attack these things. And they end up going to court. They had assessed Hartney additional monies, and it went all the way up to the Illinois Supreme Court. At which time the court said, look guys, first of all, the single test, single criterion case test, where the order is accepted, that's wrong. The regulation itself is wrong. Furthermore, it's your regulation, and you, Illinois Department of Revenue, are trying to argue against your own regulation. So what they basically said, okay, after today, that regulation is no longer any good and can't be relied on. However, due to the Illinois Taxpayer Bill of Rights, it was written authority that Hartney relied on, and they'll be allowed to do so. So Hartney ended up winning the case, but kind of everybody else lost the war. Because what they said, you can't rely on a single criterion to determine where the sale occurred and what rate should apply. So again, the case noted that business is selling, as we kind of talked before, is really the composite of many activities. So in June of 2014, new regulations were issued. And I bet that a lot of retailers really haven't gone through these regulations yet, but they have 3, arguably 4 tests in them. They consider a number of criteria. The primary test, also known as the 3 of 5 test, looks at 5 criterion. We'll discuss a couple of these a little bit. Headquarters, location and inventory, location of sales personnel, location of order acceptance, and location of payment. And what I think they're really talking about here is processing payments. Headquarters is essentially the location where the business is directed and managed, where the officers and the executives are located. And then the last point, where the daily operational decision-making occurs. The emphasis here is on the sales process and the sales executive, as opposed to, you know, general type principles and the location of general officers. Inventory is, again, where the tangible personal property is that's in possession of the retailer at the time of sale. Now, nowadays, you'll find that some retailers don't have inventory. They do it all through drop shipments or whatever. In that case, it's a 3 of 4 test that applies. Sales personnel. This is kind of a 2-pronged test. It's where the personnel is located who, number 1, solicit sales, and also have the authority to bind a taxpayer to a sale. Now, probably along the line, you may have heard the idea that, and it comes from 86-272 in income taxes, you know, where an order is accepted. Well, they're kind of getting to this here. A little different concept, but the same criteria. Now, there's some different things that are going to occur under the new rules. Here's an example one. 3 to 5 factors are at a location in Illinois. The property is shipped to the customer from a point outside Illinois. So the inventory is outside Illinois, let's say in Ohio, and they ship it. Normally, under the old rules, the rate would have been 6.25%. This would be considered what's called a use tax transaction. However, under the new rules, these new regulations, where the 3 or 5 factors are met in Illinois, the rate that applies at that jurisdiction is the rate that will apply to the sale. So that's a real change from the old rules. Okay, if no one location has 3 of the 5 attributes, then you got to go to test number 2. And it's either going to be where the inventory is or the corporate headquarters. And you have to consider not only the 5 primary activities I just listed, but 6 additional ones. So this is what I might call the 6 of 11 test. I'll go through these very briefly. By the way, I kind of thought a person in my firm was going to handle handing out this presentation to everybody, not realizing the person's just had surgery. So if you'd like this presentation that has all this stuff, also the Christmas edition, which complete with a couple of songs, Christmas songs by Robert DeLay, something like that. In any event, I'll be happy, you know, my email's here at the end of it. I'll be happy to send it to you if you request it. So the reason I'm doing that is you can see some of this gets kind of small, this print. But it's the location, the first factor, the 6, the additional ones, location where marketing and solicitation occur. The location where the seller performs activities required to procure goods for sale. So your purchase function. The location of the retailer's offices, executives, or employees with the authority to set prices or determine other terms of sale, if such determinants are made in a location which is different from the location of sales personnel. So this is more like sales policy and pricing here, a little different from sales. The location where purchase orders or other contract documents are received, when purchase orders are accepted, processed, or fulfilled in locations, which is different from the receipt. 5 is where the location where the title passes in the sale. And 6, the location where the retailer displays goods to prospective customers, e.g. a showroom. Now there's some problems here. If you notice, some of these, to me, kind of overlap the 5 primary tests. And not everybody may have a showroom. You might, you know, today we have virtual showrooms on the computer. What's going to happen in those situations? Really can't tell you at this point in time. There's been a few rulings out, like private letter rulings, general information letters, but these are so new, there's really not much out there to give you a lot of comfort. Okay, if the retailer's location, in other words, what tax rate should be charged, can be determined by using the 3 out of 5 or the 6 out of 11 test, the retailer will be presumed to be engaged in the business of selling at the location of its headquarters, as long as there is not clear and convincing evidence to the contrary. So that Illinois override rule, this is where I'd expect one instance where I'd expect it often to come into play if they don't agree with where the location of the headquarters is. So I've worked with many clients through the years where it's hard to tell where their headquarters are. More and more companies have what I call multiple headquarters. They have divisional headquarters, all sorts of things like that. So that's, to my mind, I know the gentleman that wrote these regs. He's now in private practice. He no longer works for the state. But in my mind, that was not a person that came out of industry. As many of the attorneys that work with not only our Department of Revenue, but the director, you know, Department of Revenues in many states, they don't have practical knowledge. They don't know what it's like for you working in industry to make many of these determinations. So that's where a lot of problems arise. Now there is a provision in there that said that if the inventory is in Illinois and the selling activities have been determined to be outside of Illinois under either the 305 or 611 test, what's going to happen? Well, the rate that's going to be charged is going to be the rate of the jurisdiction where the inventory is at the time of sale. And if you maybe been listening when I've been jabbering on here about saying, you're saying, wait a minute, didn't you just say the opposite a couple minutes ago? That if the inventory is out of state and the 305 rules met here in Illinois, it's where the 305, where all the selling activities are met? Yes, it did. So really the state has put in these regs, really provisions, where it's sort of like, heads we win, tails you lose. So I mean, it's that sort of thing. Now the problem here, this is really not a double taxation issue, but I do think there is a problem with this because the reason the attorney I mentioned put these in was due to an old case. I forget if it was Allied or ChemEd, and he thought that case has never been overruled. Well, it has, really. Hartney overruled it. So to me, this kind of, these conflicting rules are wrong. The other way it's kind of incongruous is because to determine where the selling activities are, you've already considered the location of the inventory. Here, you're considering the location of the inventory again. So I think this is wrong. I wouldn't be surprised if you see some litigation on this particular issue. Internet sales, again, this is some of the special rules. They're going to assume that this is going to be a use tax 6.25% rate unless there's clear and convincing evidence to the otherwise. You know, if it can be proved that the inventory was here in Illinois and shipped from Illinois at the time of sale, then that rate applies. If the customer takes possession of property at the seller's location, someplace in Illinois, that rate at that location will apply. But other than that, internet sales, if you're, say, dealing with a place in New York, that shipping from New York, it's still going to be an internet 6.25% type sale. Leased stock property with an option to purchase. If it truly is an option to purchase, you know, you're familiar with conditional sales and all that, the rate that applies is where the property was when the sale was entered into. I don't think this, are there any mining companies here or anything like that? Anybody from a mining company? Old Ben Cole, something? No, okay. I'll just say very quickly, the main rule here, even though you see a lot of fine print, is that the rate that applies is where the mouth of the mine is. Not the mine, the mouth of the mine. Don't ask me what a mouth of a mine is. I really don't know. I think it's where they take the stuff out, but I'm not sure. Another thing in here, over-the-counter sales. These are kind of what you expect. You know, it's where the purchaser is present at the place of business, enters an agreement right there, makes payment right there. That, wherever there is, that's the rate that's going to apply. And it doesn't matter if the purchaser then takes possession another time, some other stuff is delivered to them. Not many people walk in to a retailer here in Illinois and load the Sub-Zero refrigerator they just brought into their Prius. So this is what this is. They're going to have it shipped. So just the fact they had it shipped doesn't affect it. Vending machine sales, you know, typical thing, there's a machine there, it has inventory in it. You pop a coin, currency, token, something into it, delivery occurs right there. Hopefully it occurs right there. You don't have to stand or shake a machine or something like that. You know, you take immediate possession of it. That place where you're dropping a coin or whatever, that's the jurisdiction where the rate applies. Sales from vehicles carrying an uncommitted stock of goods. What they're really trying to do here with these rules is distinguish this from a place that comes out and delivers that refrigerator you bought that I mentioned before. So what happens is that, you know, it's an uncommitted, in other words, they haven't been sold, nobody's spoken for the goods yet. Best examples I can think of this are either food trucks. If you've been downtown very much, they're becoming more and more popular. The other thing is, I think Snap-on tools, I don't know if they're still around or not, but I think they used to go to various job sites, factories and stuff, and directly sell the guys kind of on the back of the So, what's the aftermath? Why am I still talking about this? Well, there's still cases going on from the RTA in the city of Chicago. We're trying to get money out of people. Anybody here ride the RTA? I do from time to time. It's getting more and more expensive, and that's why the RTA is trying to pursue this. RTA is going after places like Kankakee and Shanahan, said, look, you shouldn't have had those revenues. They belong to the RTA district. That's their bottom line. They haven't been real successful with this. I know they're not pushing it. It's kind of up in the air, quite frankly. But that's kind of their argument. The city of Chicago is a little further out yet. They're going around saying, hey, you, company A that did business in Kankakee, you end up, charging the sales tax rate down there in Kankakee, when, since you're out of state or whatever, it should have been a use tax transaction. And then that 6.25% that's charged and goes to the state, some of that goes back to the localities who are citing a portion. So the argument is we, the city of Chicago, would have gotten a little portion of that. Well, that's kind of an out there kind of argument, and a lot of people were surprised when the court took this argument. They did until I think it was either 15 or 15 new defendants Chicago wanted to add to their lawsuit. And the judge was kind of in one of these, that's all I can stands, I can't stands no more kind of thing, and said, this is ridiculous, you don't really have a case. So now what Illinois, or rather Chicago's arguing, that they had it in the wrong court. They want to go over, I forget what the name of the new court is, which means they get another judge, most importantly. And so we're wondering why they kept, that being true, why they keep their claim for 3 years in another court until they got a bad decision. But this stuff is still going on. We haven't heard the end of it yet. So, I mean, that's why the whole Hartney thing's kind of still up. Okay, now the city of Chicago did pass a new ordinance just a couple of weeks ago. And you probably heard there's been some wrangling about a couple of things in Chicago. One would be obviously property taxes, which I'm not going to address here. But I mean, property taxes, you all know, shot way up in the city of Chicago. Excuse me. The other thing was there was a ruling, a revised ruling number 12 came out for the transaction tax. And that caused a lot of, it was supposed to be effective, I think, July 1st, and was postponed to September 1st, and then put off to January 1st. So what they did, they came out, and one of the criticisms, by the way, of that was, again, didn't pass it by the ordinance. You did it by a ruling. You should have gotten a new ordinance. You had city council rule on this. So that's what they did. And the only reason I mentioned the amusement tax here is that there was some question there. The amusement tax is now also going to attack and tax things like movie streaming, music streaming, all that kind of stuff everybody's into these days. And there was some question if that might overlap the transaction tax somewhat. So what we're really talking about here is the personal property lease transaction tax. The primary thing of it is that it has a non-possessory computer lease. And to tell you the truth, I always kind of figured a lot of things they've supposedly expanded this to were already probably taxed already, arguably, under the old ordinance as it stood. I think that what they're trying to do is just make it clear. Anybody here do business or live in the city of Chicago? Okay. So we'll go over this briefly then. Where a lot of my clients get into problems is that how they tax you with this non-possessory computer lease tax. The reason actually was one of my clients from years ago, a law firm today, the last name I know it under was Thomas Frackman Mulder. They do a lot of class action suits, very profitable. And what it was is that the city wanted to tax them on the fees they paid to LexisNexis. I said, what are you talking about? That's out in Ohio. They said, the computer you asked for is here in the city of Chicago. And that's, for remember more, the city of Chicago won that court case. It's in the case of a non-possessory computer lease, the location of the terminal, which nowadays usually means laptops, or other device by which a user accesses the computer shall be deemed to be the place of lease or rental and the place of the use of computer for purposes of the tax imposed by this chapter. When they say use of the computer, they were talking, in this case, Me Data Central, the company that owned LexisNexis. So the use of the computer in Ohio, when you're accessing it by a laptop, one of these devices in Chicago, that makes that lease of it, as they put it, taxable here in the city of Chicago. Well, not here, this is the city of Naperville, but you get what I mean. Another aspect of the tax overlooked, the words lease or rental shall be included in a transfer to use of software within the meaning of this chapter only for purposes of the Illinois retailers. Application tax, which is the Illinois sales tax, and Illinois use tax, the software is not custom software, and the transfer is an exempt license of software. What does this mean? How many here are familiar with there's 5 criteria you have to have in a contract to make the sale of canned software here in Illinois non-taxable? Anybody familiar with that? Illinois has a regulation dating from a case in the 80s. And it was going to tax a lot of software. A lot of companies, especially along the Golden Corridor around here and everything, were very upset about this. So essentially there was negotiations, if you would, with the Department of Revenue that they would not tax a lot of it. So if there's a regulation that has 5 criteria in it. One is this written and signed contract, different things like that. Not terribly hard to meet, but if you meet them, there's no Illinois tax on transfer of that software. I don't agree with the city's interpretation. They came out with this actually about 3 years ago, but now they codified it. They're saying if it's not taxable because of a regulation in Illinois law, Chicago's going to tax it. I don't agree with their logic. I don't even understand their logic. But that's something they're doing. So it's not just these, where you're accessing something through the cloud now. It's actually a traditional transfer of software. And if it occurs in Chicago and you're exempt under the state regulation, you're going to be subject to this tax. To determine signacing, they're looking to the Illinois Mobile Communication Sourcing Conformity Act, and it has things in there like, like if nothing else, you use the billing address if you can't determine where the stuff's used. Generally, the tax rate is 9%, but now there's a new provision that the law brought in that it'll be 5.25% in cases in which the cloud application essentially is used for the purpose of using the provider's system to input, modify, or retrieve data supplied by the customer. So I'll give you kind of example of that. When I go into something like IntelliConnect or CCH, whatever you want to call it, like prep for something like this or do research for a client, if I do that in our downtown office, the rate's 9%. If I'm going to prepare a tax return, so I take all the data a client gives us, and I modify it and do all the secret incantations to it that turn it into a tax return, that would be subject to the 5.25%, because even though that data is not mine or not CDH's, it's supplied by us. It's a customer data that we're supplying. That kind of application would be taxed at the 5.25%. Also, too, either being the lessee or lessor of a cloud application, essentially, is exempt if the company involved is a small new business. And there are certain tests for that. Essentially, the main one is they have under $25 million in gross receipts. Quite frankly, I think there are hot dog stands in Chicago that are over $25 million, but this should apply to a fair amount of companies. But this was mom's homage to a lot of smaller companies that are complaining about this tax. As in a case when it's a lessor, in other words, it's a small cloud company, has maybe a proprietary application they don't have to collect the tax. But in a case where they're the lessee, their lessor has to obtain a certificate from them, and that's supposed to be designed by the city comptroller. Hasn't been yet. Here's just a few things. What time are we at right now? These were just a few things that were listed by ruling number 12. Here's the case I mentioned, the Midas case, Midas versus City of Chicago. Came from 1989. A couple things in this that are a little worrisome is that originally, in the original rulings, the city stated that if certain streaming services like Reuters that had stock quotes and stuff in them, that those were not taxable, that you had to manipulate the database for this tax to apply. And now one of the things they came up with there, if you'll see, it talks about to obtain real estate listing prices, car prices, stock prices, that is subject to it. So there's a little question now, are they counteracting that? Obviously, when you have stock exchanges in the city, it's kind of a big thing. There was also, and I've used them many times for many clients, there used to be a 50% rule. Something was only subject to the lease transaction tax if used 50% or more at a time in the city of Chicago. I will admit, and what the city wants to do is apportion how much of your cloud application is used in the city of Chicago. If, as a user of this, or lessee, you happen to have offices in multiple states, they'll try to figure out how much of that is in Chicago. I think that's appropriate when you have a contract that has like seat leases and things of that sort. But a lot of the contracts I've seen don't have that. They have things like bandwidth and things of that sort. That's how they determine price. In those cases, I personally think the 50% rule is appropriate, but again, in this rule, what came out, they said, no, can't use that anymore for the non-possessory computer leases. So, again, talking about the Telecommunications Sourcing Conformity Act, this means the lease tax will apply to customers whose residential street address or primary business street address is in Chicago, as reflected by their credit card billing addresses, so on and so forth. Amusement tax, a lot of people were concerned that people might confuse these non-possessory computer leases with the things that are subject to amusement tax, because now you do get certain amusements over your computer. But generally speaking, again, these are things like you think about, like downloading books, online games, video and audio streaming, things of that sort. Again, I don't think anybody here lives in the city, so I won't belabor it. Here's a case, so that's kind of interesting and kind of frightening in a way. This is the Hertz joining with Enterprise, and I'll just kind of go over very quickly what this was. City of Chicago didn't like the fact that some city residents would go out to Skokie or Evanston or Oak Park and rent a car. And they went to the places like Hertz and National Rent-A-Car, or whatever the name, Enterprise Leasing Company, say, you got to charge the 9% tax on this stuff, guys. They said, are you kidding? The transaction outside the city of Chicago, you guys don't have any authority out here. They said, well, it's fair to assume that a resident who rents a car out here is going to use it at some point in the city of Chicago. So I won't belabor with all the points of the case. Now, the case is quite long. And point by point, the court goes through it and agrees with the city of Chicago. Sure, it's fair to realize that, they might go back and use it in the city and so on and so forth. And gee, it's not hard to get information. You require a driver's license when you rent the vehicle, don't you? So on and so forth. But what this means now is for within a 3-mile radius of the city's borders, the car leasing companies have to charge the tax when they're leasing to a city of Chicago resident. Unless they give them a special affidavit, they will not take it back into the city. Now, first, this may not seem like a big thing, and for this tax, perhaps not, but the problem is here, this is giving a jurisdiction, extraterritorial jurisdiction, if you will. They can now tax things that happen outside of their boundaries. So to me, that's kind of something to watch. I mean, that could start being applied not to just cars, but to other titled, tangible property used by other companies, contractors, things of that sort. The assumption might be made that's automatically got to be taxed in Chicago. How many people either live, work, or are employees of businesses that have presence in Cook County? Just you, okay. I have to admit, when I bought my house I live in now, 26 years, I bought it 2 blocks into Lake County to avoid Cook County because my town straddles both counties. Well, here's what Cook County's thinking about. First of all, they want to eliminate the amusement tax. So kind of go in an opposite direction of Chicago here. They want to add a hotel motel tax, which as near as I can tell, because it's just a proposal at this point in time from Preckwinkle, be around 1%. They want to add an ammo tax, either a penny or nickel around the penny in category ammunition. They tried this once before, it got withdrawn. I'm not quite sure what's going to happen here. My thought, I hate taxes, this sort of tax, which is kind of like an excise tax, really started with the so-called sin taxes, liquor, cigarettes, things of that sort. The only thing I don't like about these kind of taxes, and I'll just suggest, is there's already a tax on this stuff. It's called sales tax. So you're putting another tax on top of that. My thought, those taxes make it very easy for a jurisdiction to enlarge its revenue base without its residents all fully understanding the full amount of tax they pay every year. The other thing, it also creates another bureaucracy that has to administer the tax. So I'd be more in favor of just increase the sales tax or something more yet. Now, speaking of which, they did increase it already. It's in effect, well, will be as of January 1st, but the legislation's already in place and passed. The ROT and SOT rate for Cook County, in other words, the sales tax rate, is going up by 1%. So it's going to be fairly significant. Now, if you remember, there was talk for a while, and I know a lot of businesses were very upset about this. There was a 1% use tax the county put in on non-titled tangible personal property. Things like cars and stuff are already subject to a tax, but this was other stuff that wasn't titled. And the thing I noticed now, I looked, the last time I looked was a couple of weeks ago, so they might have changed this, but if you look, at least when I did on the Cook County website, even though they lost the case on this months and months ago, they still have the tax up there. If you're going through their website, you would probably assume you still owe it. So I just want to mention that to people so you don't, in error, pay it. In fact, what I would suggest, if your employer has paid the tax and hasn't gotten a refund, so it suggests to them they should file for refund. The form's hard to find, but that's because it's not a special form as you would expect. It's just this general tax refund form they have. If you need one, and you can't find it or like one, let me know and I'll email it to you. Okay, what's up for consideration, I guess? And this is all pretty much consideration, just kind of wondering about what's going to happen, since the situation downstate is pretty much up in the air. You know, as you know, for 2015, the overall corporate, that C Corp rate, went down from 9.5% to 7.75%. This is with the replacement tax figured into it. So when a budget's passed, the idea is, are they going to wipe out that decrease and put it back to where it was in 2014? Or will they increase it even more? It's hard to say, but most of the people I talk to in the Department of Revenue that have been there some years think it will go back up. It's a huge hole. Illinois is having trouble replacing it. Will the MPC be restored? How many people here remember the MPC? Not too many. MPC was the manufacturer's purchase credit. When you got exempt property, things that were exempt because of the M&E exemption from manufacturer, you earn MPC and you could apply that against the sales taxes due on things that weren't exempt. It was extremely labor intensive for the amount of credits you had. So unless you're a company like Caterpillar or something like that, it was a little, I know companies that just gave up on it because I'm not, controller would tell me, I'm not going through that. So there are companies that actually go around for 1% of the MPC would figure it out for a company and file all the forms. Will it be restored? Originally, when it sunsetted, I thought it would be, but more and more I'm of the opinion, and I think more and more people are, that this is not going to be restored. And one of the things I'm hearing from people is that it was very complex, difficult to administer, both from the aspect of the taxpayer and also the Department of Revenue. So I personally I'd be surprised if this comes back. I do know there was a bill put up downstate, maybe you guys are familiar with it. It's kind of like the original bill that caused the MPC to be created in the first place. And the reason that bill didn't go through is like an expansive M&E type exemption. That bill kind of failed among other reasons because, again, it was considered too expansive. But I do think if you see something like an MPC come back or something that's a kind of a little bit of a gift to manufacturers, I think it's going to be not the MPC, it'll be something different this time around. Will changes be made to the UPIA, which is not a cowboy thing, even though it sounds like it. Anybody know what the UPIA is? Or UPIA, as we affectionately call it. It's the Uniform Penalty and Interest Act. This is what government works for every tax in Illinois, determines how much penalty or interest they're going to ding you for just to rub a little more salt in the wounds. And you get assessed. They're talking about this now. I also belong to the Illinois Director of Revenue's Advisory Board. We met, I think, I want to say in April. I just got a notice that we're meeting again, I think, December 10th. This is one thing brought up by the director herself, the new director. She believes that a lot of the response times for like protests and stuff are too short, causing a lot of problems. And it's causing the governors in office to get a lot of flack on this stuff. So there may be some changes made to this that I think will largely be regarded as taxpayer friendly. There's also been suggested maybe they should lower some of the rates a little. I don't know what the state's current situation if that's going to happen. Well, there I am, and there's my email address. If you'd like this, I'd be more than happy. Just send me your email. I'd be more than happy to email the presentation to you. So at this time, are there any questions? I'm assuming the reason there are no questions is I've done such a thorough job explaining this, and not because everybody's kind of already sleeping. But if there are otherwise, I think we'll be around here for a while, and I think we have like a Q&A section later or something like that?
Yes.
I'll be hanging around for that, so please let me know. In the meantime, thanks very much.